Namo Ariyantanam, Namo Siddhanam, Namo Ayariyanam, Namo Vachayanam. Padamam Havai Mangal.
Good evening, everyone. A warm welcome to one and all present today. On behalf of the management and the training team, I take the opportunity to welcome you all for today's session. I would like to welcome our speaker for today, Ms. Ipr Balasubramanian. She has a master's in bioinformatics with over 10 plus years of experience in IP. She is a registered patent agent and experienced prior art searcher with over 11 years of overall work experience. Her primary focus on drafting and prosecution of application areas of molecular biology, genetics, paramedical chemistry, and nanotechnology, bioengineering, medical devices, and AI. She also possesses rich prosecution experience in jurisdiction like IN, US, and EP. She assists clients with prosecution queries, advises startups and independent inventors on matters related to production of IP. Once again, we welcome you, ma'am, and over to you for this session. Thank you.
Thank you so much. Thank you so much for the very nice introduction. All right. So apart from that, I'm working as a patent attorney with ZACO. And I'm also working as a senior patent attorney with SNH Partners, where we also work with a lot of academic institutions throughout the country in assessing their invention and also helping them to identify the patentable aspect of their work, draft their application, file and prosecute the same with Indian Patent Office until the grant of the patents. Moving on to my slides. I'm just sharing my slides. Is it visible?
Yes, ma'am.
All right. Please stop me if you have any doubts. You can also message me over chat. Moving on to our topic, IP and its practices in academics. Why IP in academics is important? So we all know that universities and public research institution or public funded research institution or the factories of knowledge economy. So this IP protection adds another mechanism in order to disseminate the knowledge that is generated by the academic and research institution. And also they liaise in commercialization of whatever is happening in their laboratory to take it to the industrial scale, and after which it reaches the community. So I'll move to the next slide. So intellectual property, what's the funda all about? Let's know what is intellectual property. I'm brushing upon some basics. So intellectual property refers to creation of mind, be it inventions, any literary or artistic work, and symbols, names and images which is used in commerce. So these things come under specific intellectual property, which we will see in detail. Intellectual property covers mainly patents, copyrights, trademarks, geographical indications, trade secrets, semiconductor and plant varieties. So in my presentation, I'm going to focus mainly on patents, copyrights, and trademarks. We can also talk about geographical indication and other types of intellectual property. But if I have to cover the scope of everything, it falls outside the ambit of the topic we are dealing with. So why IPR? IPR is required to enable people to earn recognition and financial benefits for whatever they invent or create. It also plays a key role in research and teaching function of universities and public research institution. What comes under IP in case of universities or public research institution? So it basically deals with the research work and also kind of work they collaborate and do it with third parties. So I'm moving on to next slide. And why do you think IP protection is important? So when you have your work protected by intellectual property rights, it increases the likelihood of commercial partners who would want to work with you. They can also, provide, like venture capitalists, they can fund your research, and also they can commercialize your technology. So that's why having your research work protected under IP is very important. And it also gives you a right to stop others from copying and benefiting from the research work you had, so far worked on. And also one important aspect of having your work protected by IPR is anything you give for free doesn't have any value. On the contrary, if you give your research work, research output as free to the, to the rest of the world, then it is counterproductive. In the sense, if you don't have fund, you cannot further invest on further research. So that's why you need to have your work protected by IPR. Let us move on to IP and research. So what is the kind of IP is there in your research work? So universities and public research institution, through their research and development, produce results in the form of, just a second, in the form of invention, mainly scholarly publication, as in when you publish your article in leading journals, that also forms a part of IP. And when you generate databases which has unique data, artificial intelligence is something catching upon these days. For anything and everything, you have artificial intelligence. And I'm sure 2021 generated lot of patents which are dealing with artificial intelligence. So in that way, even that comes under IP. And new plant varieties, confidential information which is covered by trade secret, computer programs per se is copyrightable, and yeah, and various other publications. So there are certain aspects which are protectable by IPR, and there are certain aspects which are just proof of concepts, and which are laboratory scale prototypes, which cannot be blown into a full scale invention. That also requires, maybe that is just a concept or a theory which requires further R&D, in order to be commercialized. So how do these universities and public research institution, help in, bringing the technology to the market? It is mainly done through IP commercialization, wherein the technology or the, research work you carried on in a laboratory, reaches the market, where it is scaled up, has industrial process and products. So it is done through IP commercialization. So IP and teaching. So what is involved? What is IPR involved in teaching? When it comes to teaching, you generate a lot of reading materials as print publications. There are also software programs, software codes used in demonstrating a certain process. Even that comes under IPR. And there are many short films which describes your technology and use of a particular product which you have developed. That also comes under IP and IP generated through teaching, sound recordings, computer presentation, and multimedia works. So how do these works are? I'm sure these works are not protected under patent. These works are protected by copyright. There is a need for suitable IP policies to deal with certain things which is happening in the teaching world. So we need a better ownership and management of teaching materials, which is not standardized as of now. We need proper access to the scholarly information to use in our research, and how the use of third-party materials used in our research is being regularized. That also lacks clarity. I will explain in detail about the IPR policy we have in place now. Which explains more about how to use when you collaborate with third party and use their materials for your research. When it comes to IPR policy used in academics, especially in India, so Indian government, they issued this national IPR policy in the year 2016. So the main objective of this policy is to spur creativity and innovation. So under this policy, government established a cell for IPR promotion and management, which is called SIPAM, under the auspices of Department for DPIIT, Department for Promotion of Industry and Internal Trade. So the main aim of SIPAM is to facilitate promotion, creation, and commercialization of IP assets which is generated by the academic institution. So the SIPAM, they published a model guidelines for how this IPR policy has to be implemented for academic institution. So this presentation is majorly about those model guidelines which are set for the academic institution as well as the researchers. So by delving deep into this model guidelines, you would have a fair idea of what is covered, has IPR in your research. So the main objectives of these model guidelines is to foster innovation and creativity. And IP rights, to obtain IP rights for the innovative and creative work generated by the faculties, personals, students, and staff of the academic institution. So the other main objective is to, develop a transparent administrative process for ownership, control, and assignment of IP rights. The other objective is to promote more collaboration between academia and industry, so that you can harvest more process and products, and commercialize the same. The mechanism of a mechanism for knowledge generation and its commercial exploitation. And the other important objective is to establish an IP cell, which is a centralized one, which can be consulted by any researcher throughout the country, so has to protect their invention as well as to commercialize the same. It is IP cell is not only for the researchers, it is open for students as well as faculty members. So technology transfer and diffusion. This slide covers, what and all comes under IP with regards to what is generated by academic, the kind of knowledge generated by academic institution or a researcher or any faculty working for an academic institution. So knowledge and innovative technologies from universities are transferred and used for scientific, technical, socio-economic, and commercial purposes. So this includes publication of any type of information in journals, which is based on the research developed in the academic institution. So any kind of publication, journals, scientific magazines, and the like, and presentation conducted in conferences, delivering lectures, courses, etc. Patent documents. When you file a patent, the information covered is also, a kind of knowledge which is disseminated to the public. So assignment and licensing of technology, R&D contracts, sponsored research or contract research, institution industry collaboration of staff, startups or university spin-offs, and what's been disclosed in your postgraduate or doctoral or postdoctoral projects. Students who who are placed, entering on-board jobs, consultancy by university staff, all these comes under, IPR protection. So patent rights in collaboration projects. Before that, I'm sure all of you have a fair idea of what are patents. So patents are ideally inventions and which has to have three important, which has to be new, it has to be inventive. Inventive means it should not be obvious to the person skilled in the art. Novel or newness means it should not be told in any prior art. And it has to be industrially applicable. So these patent rights will let you control the destiny of your invention by choosing who can make, sell, or use your invention. So the duration of a patent is generally 20 years. So in a scenario where you think your research work does not qualify for a patent, in the sense it is not technically exhaustive to apply for a patent, you can go in for a defensive publication. Defensive publication ideally means publication of details of a technology. In any, there are specialized website which does this defensive publication. So by through this defensive publication, you can ensure that nobody can patent your research, which is not patentable. So a defensive publication is also cost effective. So let's see, what are the patent rights especially when you collaborate with a third party. universities and public research institutions frequently work with collaboration with businesses, governments and other institutions in order to exploit their research. So these model guidelines clearly says that it applies to researchers who have signed any kind of employment contract or agreement or any such related documents. So when if you are a researcher working for a university, by default, you have signed the agreement that whatever you do working in that academic institution by utilizing their resources or funds belong to the academic institution. So this is a default agreement. Yeah, that's what invention developed by students, researchers, and faculty members belong to the academic institution, developed by utilizing their resources, funds of academic institution, or utilizing mix of their funds, resources, and or other facilities of the academic institution. But in a case where academic institution determines that an invention generated by an individual in their own time, so which is unrelated to his or her responsibilities while working in the academic institution, and the invention was conceived and reduced to practice without the use of resources of the academic institution, so then the rights of the invention vest with the individual or inventors. So assignment of rights in such patents is governed by the same principle. So two cases: when you have used academic institutions funds or their facilities or their resources to zero in on an invention, then it belongs to academic institution. In a case where you haven't used any of their resources, but you have developed the invention, that idea was developed and reduced to practice on your own, then all the rights vest with you. So assignment of rights in copyrights. Copyrights is the second biggest form of IP after patents. I'm sure you all know some basics of copyright, but anyways, I'm touching some basics of it. So copyright basically protects original works and give creators various rights over their work for a limited period of time. So I will come to the term of copyright later. So let's see what the copyright owners, per se, what kind of rights they have. Owners of a copyrighted work can basically authorize or prohibit use by others. They can also prohibit or authorize reproduction in various forms, as in print publication or sound recording. They can also authorize or prohibit distribution of copies of the work, as well as public performance. So and also broadcast or other communication to the public, and adaptation. For example, we all know that Chetan Bhagat's novel has been, adapted as a movie. So even before making that movie, they would have obtained copyrights from Chetan Bhagat in order to adapt it as a movie. So if you don't get the copyrights, then Chetan Bhagat has the right to sue you. And the other famous or infamous, how do you call it, copyright tussle is between the living legendary composer Ilayaraja and the equally but late legendary singer SPB. So duration of copyright is generally lifetime of the author plus 60 years. So after 60 years, after the demise of the author, the work of the author enters the public domain. So anybody can use it after 60 years of the life of the author. So what does copyright cover? Some of the original works of copyright includes books, lectures, speeches, translation, plays, musicals, dance performances, music, films, video games, works of art, drawings, photos, sculptures, architecture, visual arts, computer and software databases and a website. When it comes to website, most part of the website or copyrighted mobile applications. I mean, lot of mobile applications. We are living in the world of mobile applications. Of course, original database. These are all covered under copyrights. So copyright ownership rights in scholarly academic works generated even while utilizing the resources of the institution is vested with the author. Ownership rights in lecture videos or massive open online courses. As in, there are a lot of online courses available these days. For example, NPTEL courses has listed. NPTEL has listed a variety of courses. I mean, you can use their videos on a particular topic. You can also, appear for examination. In that case, I mean, all the rights belongs to the academic institution. Yeah. Ownership rights in plays, musical works, institutional materials commissioned by the academic institution belong to the academic institution. Whereas in both the cases, the moral rights, that is, moral right denotes a right to have a work published anonymously or pseudonymously, and the right to the integrity of work is vested with the author. Basically, the right to attribution rests with the author. Trademark rights. Yeah. Some basics of trademarks. A trademark represents a name or a brand name or any kind of logo which is used as a tradable business asset of enduring value. So the benefits of having a trademark right is to boost your brand image and reputation, to generate income, to give an indication of the value of your company for potential partners and investors. You can also use your trademark right to prevent others from free riding on your investment. It serves as a, you can also use your, trademark right against, has a collateral against loans. To give you some examples, Bata, SBI, McDonald's, all these are, very established trademarks which has gained value, commercial value due to long term of usage. So yeah, the kind of value Bata products have is known by everyone. So yeah, in case of academics and research, ownership rights and trademarks, which involving the academic institution, as in, when you use your academic institution symbol or any kind of cultural event in which a certain thing happened. For example, a dance show happened in a particular cultural fest. So the rights and all these things, the name of the cultural event also can be trademarked. So all these things belong to the academic institution. Guidelines for using the trademarks which belongs to the academic institution is generally formulated by the academic institution. So if an academic institution determines that the trademarks were created by the individuals on their own time, again, which is unrelated to their his or her responsibilities. For example, I mean, a student studying in a research institution, I mean, begins a company or a startup venture, and he has a name which is unrelated to the academic institution. So in that case, the trademark rights vest with the individual who had, started a company that is not even related to the academic institution. So industrial designs is the next big form of IP. Design represents an aesthetic, I mean, how the size, shape, and contour of an object appears, I mean, is denoted by a design. So when you have the term of these designs, with regards to India is 10 years. So the potential benefits of having a design right. For example, to make you understand better, the shape of a Coca-Cola bottle is protected under design for designs of design form of intellectual property. So when you have a design right, it gives you an enhanced commercial value. It helps you to generate income, wherein you can create revenue by licensing your design rights to others to use. To use your design for a fee, for a royalty fee. And having a design registration would also help you to have a stronger market position. And the other well-known example is the paper boat juices you see in the market. The shape is so unique, which is unique to that particular product. So when you have a design right, it serves as a protection against infringers. So again, the same thing which applies to patent applies here also. Industrial designs developed by students, researchers, and faculty members belong to the academic institution, which is developed by utilizing the resources or funds of the academic institution, or with a mix of funds, resources, and the facilities of the academic institution. But if the academic institution determines that the industrial designs were created by the individuals in their own time, which is unrelated to his or her responsibilities, and was conceived to reduce to practice without the use of the resources of the academic institution, then the rights of such design invention vest with the individuals. So next, coming to the semiconductor integrated circuits and plant variety rights. So what is plant variety protection? So when you come up with a new plant variety, for example, a plant which survives all different climates, then you can apply for a new plant variety protection right. So in India, the term of a plant variety, there are different types of plant varieties. I'm not delving deep into that, but generally the term varies between 15 to 18 years, depends upon the variety you're coming up with. So having a plant variety protection right means plant breeders can achieve a return on investment. It also helps you to helps to provide farmers with new improved varieties that can respond to climate change and provide and therein provide improved food security. So it can also allow the public sector to target benefits for public good. It can also facilitate partnership to achieve common objectives, share developmental costs, and promote marketing and distribution of resulting plant varieties. When you have a plant variety right, you can maintain the value and reputation of their variety by controlling the quality of your variety. Ownership rights with regards to utilization of resources of academic institution. When you use academic institution resources to develop the plant variety, then the rights in the plant variety goes to the academic institution. The same applies to integrated circuits also. But whereas if the academic institution determines the semiconductor IC layout or the plant variety were created by individuals in their own time, which is unrelated to his or her responsibilities and was conceived to reduce to practice without the use of resources of the academic institution, then the invention vests with the individuals. So what are the things to know about IP confidentiality? Some basics of confidentiality aspect before you decide to file an IPR right. File an IP has to be known to any researcher or student or a faculty who have decided to protect their invention or their trademark or their copyright. Publication or display in public exhibition or of invention before filing for patent is generally discouraged. Why it is generally discouraged? Because such publication or display leads to the lack of novelty. When novelty is lost, it basically loses the hence it cannot be patented. So novelty, as I said in the earlier slide, novelty, inventive step, and industrial applicability, or the three main pillars that is required to get your application, to get a patent for your research. So yeah, so what contributes to this publication or display in public exhibition is when you disclose your invention at an international exhibition, or when you disclose about your research work in a journal, book, poster, or any kind of publication, or when you talk about your invention in a website or any other electronic means or in a social media, or disclosure through oral presentation, or even disclosure to someone. For example, that person may be interested in your invention, so has to fund your, he may be a potential investor who is not under an obligation to keep the information confidential. So in all these cases, it is, not in all these cases, especially when you want to disclose your invention to someone, have a non-disclosure agreement in place before, talking about your invention. So even if you have displayed your invention in a public exhibition, or you have published your invention, India have a grace period of 12 months. So if you accidentally disclose your invention to someone or somewhere, you have a grace period of 12 months. So within this period, if you have filed a patent application, then it will not be a problem, in destroying the novelty aspect of your invention. So researchers would also want to know what are excluded from patentability. There are a whole lot of invention which comes under non-patentability. So, and it is covered under Section 3 and Section 4 of the Indian Patents Act 1970. So I will touch some basics on what is not patentable as per Indian Patents Act 1970. So invention which are not patentable, this comes under Section 3 of the Patents Act 1970. The first one is any frivolous invention which is frivolous or contrary to well-established natural laws. For example, if somebody comes up with a perpetual motion machine, or a machine which gives more than 100% of efficiency, then you cannot patent such invention. For example, if someone comes with a clock which has more than 20 which has more than 24 hours, then it is against well-established natural laws, so hence it is not patentable. Any invention which is contrary to law or morality, or injurious to public health or scientific principle or formulation of abstract theory. So contrary to law or morality means, for example, if somebody comes up with a device for house breaking, or if someone comes up with a gambling machine, or someone comes up with a method of hacking email account of others. So it is all these are contrary to law or morality, or injurious to public health. So therefore, those things cannot be patented. Scientific principle or formulation of abstract theory. So yeah, even Newton's law of gravity cannot be, however big they are, it cannot be patented. Einstein's theory of relativity, all these things cannot be patented. So yeah. And the discovery of natural gas, or anything occurring in nature, or any natural element, all these are not patentable. So the other important aspect of non-patentability is new property or new use of known substances. So for example, crystalline forms of chemicals are not patentable. Yes. So mere use of known process, machine, and apparatus. For example, uses of when you say you have identified a new use of a plant, for example, a neem plant or a turmeric plant, you cannot patent it because, turmeric and neem, they are known, they are known for their medicinal properties for a long time. So if you come up with a new use, then you cannot patent the same. Mere use of known process, machine, or apparatus. For example, a torch fitted to a bucket, and a clock with an alarm. For example, clock is doing its own work and alarm is doing its own work. So if you attach both the machines into a single machine, and if you ask for a patent, and sorry boss, you won't be given a patent. So, a substance obtained by mere admixing. A component A does something, component B does something else. So, for example, this is just an arbitrary example. If pepper, turmeric, and ginger have certain properties. So when you mix these three and claim a herbal formulation, but there is no synergy achieved. So each component are working its own. Synergy means added effect. There has to be an added effect if you mix 2 or 3 components. So when there is no synergy, then no patent. So when there is a synergy between, if you achieve a synergy by using different components, then it is, you can get a patent for that. Mere arrangement, rearrangement, or duplication of known devices, which is what I said. A bucket fitted with torch. So torch does the activity of, giving the light, and bucket helps in holding the water. So in that case, nothing is new in your invention. So in that case also it is not patentable. Method of agriculture or horticulture. If you claim that you have developed a new soil for cultivating a particular crop, then that is so absurd that cannot be patented. Horticulture, if you have come up with a new way of, cultivating wheat or rice, then, they also, can't be patented. Any method of treatment of human beings, animals, plants, animals in whole, or any part other than microorganism. For example, a process of surgery is not patentable. Any method of treatment of a disease is also not patentable. So if you come up with a method for increasing the production of wool from a sheep, then that is also not patentable, because you are doing something to increase the commercial and economic value of a particular process or a product. So hence it is not patentable. So the other things which do not fall under the ambit of patentability is a mathematical or business method, or computer program per se, or algorithm. Computer program per se is not patentable, but when you develop a hardware which achieves certain technical solution using the computer program, then it is patentable. A mere scheme, rule, or method of performing mental act or playing game is also not patentable. For example, Sudoku, and for example, the newly launched game which people are crazy about, Wordle, or any method of solving a crossword puzzle, all these cannot be patented. A presentation of information is also not patentable. Topography of integrated circuits. And this is very interesting. People mostly come up with herbal composition, or any kind of composition which which ideally helps to cure a particular disease. So in those cases, they would have used the traditionally known components to achieve a certain solution. So even in that case, those invention cannot be patentable, because the information, the traditional knowledge we know about lot of herbs is being documented in traditional knowledge digital library. Hence, whatever has been told to us traditionally by our ancestors and forefathers tends to fall in the public domain. Hence, you cannot use it to, patent it as your invention. So the final thing is invention which are related to atomic energy are strictly not patentable. So things to know about confidentiality. Part 2 is so far we have covered about the patent aspect of IP confidentiality. Moving on, we'll cover the copyright aspect of it. Acts that do not, there are certain acts that do not constitute infringement. So section 52 of the Indian Copyright Act 1957 specifically states that certain acts do not contribute to infringement of copyright, and those are termed as doctrine of fair dealing. Doctrine of fair dealing allows use of copyrighted works for the purpose of education, especially for teaching, disseminating knowledge to the students, using those copyrighted works for research, critic review, etc. So when you use those kind of copyrighted works, make sure you give a proper attribution or get copyrighted license from the copyright holder. So attribution or citation should be done wherever references have been sourced from other works. So it requires permission and licenses to be obtained from the author or creator. So when you don't give attribution to those copyright holders, then it is ideally termed as plagiarism. And as you all know, plagiarism is illegal. So the good practice is to keep a record of all legal and related documents. So when you collaborate with a third party, make sure you have all the agreements and all data covering IP, like lab record books and records to be documented since the inception of an idea. So when you look to, trademark a particular word or a logo, make sure you do a simple prior art check. So we Indian Patent Office allows you to do a basic search before apply for a trademark application. So a simple prior art check is necessary while choosing a name or a brand name. Why it is required? This will avoid unnecessary conflict with the existing registered trademarks. So what to know about IP in case of collaboration projects with external partners? Ownership of IP in research is as per the terms and condition of the agreement signed. So when you enter into an agreement, you should make sure all the clauses are as accepted by the mutual parties. So academic institution generally retains perpetual royalty-free license to use the IP for research and educational purposes. So unless there is a clause, unless that is agreed upon explicitly, in case of absence of any such agreement between an academic institution and a third party, generally, or the academic institution and the researcher, the rights, IP rights, is mutually shared between both the parties. Commercialization and benefit sharing. So when it comes to the commercialization of your product or your invention or your intellectual property, it is governed by two main modes, which are licensing and assignment of IPRs. In both the cases, you transfer your rights to another party. In licensing, it is your rights is limited to permitting certain uses, whereas with assignment, it involves the transfer of entire ownership to another party. Types of licensing. So there are different types of licensing, say exclusive, non-exclusive, sub-licensing, and combination licensing. So in exclusive licensing, generally sole IP rights is licensed by the licensor to one licensee. Here, your entire IP rights has been transferred to one licensee. In that case, you cannot, in future, if you want to work on that, if you want to work further in that particular research for which you have obtained IP, You cannot, because you have, given the entire IP rights to a licensee. Now he has the sole right to do whatever he wants with the um, uh, with the with the invention. So generally it is discouraged. I mean, people do not encourage to go in for an exclusive licensing. So when it comes to non-exclusive licensing, a licensor is permitted to enter into agreements with more than one entity. You can have multiple licensee. You can give your same IP rights to 2 or 3 different persons. Same IP can be used by different licensees at the same time for the same or different purposes. So sub-licensing, if you give a licensee to a one particular person, who in turn further licenses the same IP to a different person, then it is called as sub-licensing, when a licensee wishes to further license IP to another party. So in this case, the agreement between the first person who shared his IP rights to a licensor has to clearly and explicitly mention that he has the permission to sublicense it. So without that particular clause, you cannot sublicense it to another person. So in other cases, combination of licensing can be used. The other form of licensing is know-how licensing. Yeah, coming to benefit sharing, revenue sharing. Yeah. Based on the research outputs generated as a result of utilization of resources of academic institution can enter into various kind of revenue sharing agreement as per the advice of IP cell. Generally 60:40 ratio is followed, wherein the 60% of royalty generated by licensing goes to the researcher and 40% goes to the academic institution. You can also, decide the division of royalty or technology transfer based on fixed slabs. You can have an arbitrary cost. For example, in the table I have mentioned, Q has a fixed cost, and certain percentage goes to the inventor, certain percentage goes to the institution, and some money to the service account. So generally, money in the service account may be used for the promotion, upgradation of your invention, to work further on your invention, and then promotion of commercialization of the same. IIT Kanpur has 100 lakhs as their fixed slab. So similarly, other institutions also have different kind of slabs, and it is generally decided by the capacity of your invention. How what kind of what breakthrough it has achieved, and it is generally determined by the academic institution. Revenue sharing in collaboration with external partners. Revenue sharing on IP generated between academic institution and external partners is based on the agreements shared. So if the assignee or licensee has not taken adequate steps for the commercialization of the academic institution owned IP, then academic institution has all the right to revocate the existing license and assign it to another party. So this particular clause has to be included in the agreement between the between the academic institution and the party to which it is going to license its rights. Addition of such a clause in any agreement is mandatory with regards to commercialization. Sharing of costs with regard to IP protection. If academic institution is the sole owner, then the cost involved in filing for a patent, prosecuting it, and then pay for examination, maintaining the patent. Similarly for trademark designs, the cost is generally borne by the academic institution. In case if academic institution refuses to bear costs, then the inventor may be allowed to file IP in the name of the academic institution at their own cost. So in that case, IP filing costs can be reimbursed as per provision relating to benefit sharing. Okay, IP ownership is shared with external partners. Cost of IP protection is shared by both the parties based on the terms and conditions of the agreement in place. The cost involved in transfer of rights or ownership of academic institution owned IP is borne by the licensee, assignee, or person acquiring such rights. So if an academic institution owns a certain IP portfolio and it decides to transfer it to a business entity, I mean, or an industry, so in that case, the transfer of ownership rights vests with the person who is getting the rights from the academic institution. So the use of academic institution IP resources. Generally, academic institution doesn't allow the use of its IP everywhere. It has certain requirements. By fulfilling the same, you can use the IP resources of an academic institution where you intend to. Academic institution may allow use of the following IP resources by third parties based on certain condition. So in that case, IP has to be in place and it has to be owned by the academic institution. Usage of name, logo, or trademark of the academic institution in the creation and marketing of IP is generally used for the for promoting the academic institution name as a brand. So you can use your academic institution IP resources in cases of public interest. It will also be used in responsible manner to create a product or process conforming to environmental safety and good manufacturing practices, which is promoted by Government of India, in promoting truthful claims and information that is not for misleading society or users, without any liability on the university in case of misuse of trademarks or accidental damage accruing due to use of trademarks. Use of technology protected by patents and designs. Technology, design, or software which are generally protected by patents are widely used in research. In that case, certain care has to be taken so that you're not infringing IP rights of any of the third parties. You should also make sure that you obtain the required licenses, from the copyright holder, so that you don't infringe their rights and enter into infringement suit. Use of copyrighted materials. Use of copyrighted materials for teaching or research purposes should be within the permission obtained from the concerned copyright holder. So it is generally advised to have an institutional repository, which has and a link to the website has to be provided to all the academicians working or studying in that particular academic institution. So an institutional repository generally has dissertation of all the students, thesis submitted, their papers, publication, and other in-house publication. So in the absence of such repository in an institution, you're encouraged to submit your work in open repositories. But one thing that has to be taken care is when you publish your work in an open repository, you automatically enter into open licensing agreement, wherein other researchers can utilize your research outputs, but they have to give proper attribution to you because they have used your research outputs in their projects or their presentation or their publication. So government also encourages all the academic institution, researchers, and students to use this free and open source software. Generally, why it is encouraged is the use of free and open source software can help in furthering the software related skills of students and researchers. Confidentiality, data protection, privacy of IP generated by academic institution. All uses of information, documents, and all activities pertaining to the use of information within the academic institution. For example, you must be using their books. A previous year student's dissertation work or any such data which belongs to the academic institution. So when you are using the resources of the academic institution, make sure you're keeping it confidential. So academic institution generally should strive to protect the data and personal information against unauthorized access, loss, destruction, or breach. So in all these cases, you should have a proper non-disclosure agreement in place, so that none of your precious research data falls into the public domain without unauthorized access. Research publication, any publication document and or a paper arising out of research activity shall be owned jointly by the academic institution and the researcher who is contributing to the research work. Use of name, logo, and official emblem of academic institution requires the permission from the academic institution. Better both academic institution and researcher jointly decide on the publication. By this, I mean that you can always decide on what has to be disclosed to the public and what has to be kept confidential. The contents of the public publication can be jointly decided by the academic institution as well as the researcher. So care has to be taken that you don't publish anything without filing a patent application. If you think that your invention or your work is capable of being patented, then never disclose the invention without filing a patent application. Academic institution may retain, as said earlier, academic institution may retain the right to require exclusion of certain portion from the information being published. Yeah. That ends my presentation. Before that, I will give a checklist of for researchers to consider when they, especially if they think their work can be protected under any form of IP. So some of the initial consideration for researchers are, please assess who owns the IPRs arising from your research work. So what is the university's commercialization strategy involved? And what are your rights and obligation? In all these cases, you have to contact your technology transfer offices. You have to discover what is a material transfer agreement. You have to discover the patent or patents lying in your work, for which you need to do a search in various IP databases. So as a checklist, I would suggest the following. Before begin to think about gaining a IP right for your work, check your university's intellectual property policy. Make sure you keep detailed notes of your research work. Point number 3, submit an invention disclosure form whenever you feel you have discovered or created something unique with possible commercial value. Point number 4, mention all contributors to an invention or creation in your invention disclosure form. Point number 5, do not publish your research before it is protected. Point number 6, check if you are using materials or IP from others in your research. Point number 7 is research patent literature. Generally, researchers do not tap the potential which is mentioned in previously filed patent literature. It's a mine of business and technical information. So research patent documents also don't rely on only non-patent literature. Please do have a look at patent documents before working on your research. Check how license revenues are to be distributed and what share you will have. I have mentioned a technology transfer office. So generally, technology transfer offices provide access to some of the key services to get a IP right. So it helps in evaluation of your invention's commercial potential. It also gives you an advice on how to protect, deploy, and manage your invention. Technology transfer office generally helps in or supports you in licensing your invention. It also supports you in setting up a spin-off. Especially you think you have a lot of ideas to invest in a startup or a spin-off and have huge potential to commercialize your product, and you're thinking of a spin-off, you can contact your technology transfer office. So, and also another aspect you would want to know is material transfer agreement. What these material transfer agreements generally do, they set out the terms for the exchange of the proprietary material which you have zeroed in to a third party. And it is generally used in research work, feasibility studies, and prototypes for testing or trials of your product or process. So the checklist which you would require in creating a material transfer agreement is, you should generally be clear about the terms of the agreement, duration of the agreement, details of the IPRs to be exchanged. For example, you must be having a whole gamut of not only invention but trademarks, copyrightable aspect also in your work, which you would want to cover under IPR when you enter into an agreement with a third party. And you should also know the types of licensing you will be using it for the for the benefit of you as well as your researcher. And arrangements, especially in case of ownership, who will own what, and access, especially if you come up with the improvements of your research. You should also define where you're going to use the invention. For example, the invention you have come up would be useful not only in India but also for the people in Africa who are facing certain kind of problem where you think your invention will be greatly useful. Then you can decide the geographical scope of your invention as well. In case of any dispute which arises between the third party and you as academic institution or a researcher or student, you should have proper dispute resolution clauses in place, and you should also see to that applicable laws are mentioned wherever possible. So these IPR rights will also facilitate partnership with third parties who generally have a lot of commercial interest in working with you. IPRs are generally used as assets to contribute to a partnership. It is a way to harvest the output of collaboration by generating new IP assets, and the benefits which you accrue by entering into a partnership as access and or develop new technologies, reduce R&D costs by sharing your costs involved, and also sharing the risks, and you can enter new markets and scale up your business. Yes, and that ends my presentation. Any doubts or any questions? Hello?
Participants, if you have any query, you can ask. You can type in the chat box.
For designs, one second. You want to know about design, right?
Yes, ma'am. They have asked for product design.
Product design, it is 10 years. Okay, unmute you, Geeta, right?
Yeah, ma'am. Good
Just a
evening,
second.
ma'am. Yeah,
Good
now
evening.
it is unmuted.
Okay.
My question is that if, as you are saying that researchers should know the institute's policies about the patent, but
Yes.
the many of the institute, they do not disclose the policy to the researchers, the new researchers. So what people have to do?
No, generally it has to be open, especially if you're filing a patent along with the academic institution. You should know it. You have the right to know it. In what aspect you would want to know?
Means suppose before joining the institute, in the project, or suppose I have the project and running that project into the institute, if I know their patent policies, in that case, I should be more comfortable whether the institute will give me the
yes,
good
exactly.
expenses, a good reality or royalty. Otherwise, just they will just say that you have to do the invention and give the all rights to institute.
Yes. I mean, generally, if your invention is being commercialized, you should be given 60% royalty, and 40% of royalty which comes out of licensing your technology goes to the academic institution. So that is generally followed by all academic institution. In case they do not clarify you, you can contact any of IPR facilitation center of your state. For example, if I mean, if you are from Tamil Nadu, you can contact IP cell of Tamil Nadu.
Ma'am, can I give a few clarification and insight on this question, ma'am? I'm Dr. Deepa, the research director of the institution who is hosting this program, ma'am.
Sure. Go ahead.
Dr. Priya, ma'am, like as far as the industrial IP policy is concerned, you should give a formal letter to the principal seeking that you want to be a part of a project as a PI, a principal investigator or co-investigator. And then it is without signing the IP policy, you cannot get into the projects, ma'am. The first thing you have to do is, if you have a research director in your institution, you have to send a formal mail or a formal communication to the research director. If not, you can directly communicate to your principal, so that it is the bounded duty of the higher authorities to give the IP policy. And in fact, if you are enrolled for a project, and if you are enrolled for a project, you have to sign the IP policy before you register yourself for the project, which is funded by agencies, ma'am, because you represent the institution. No, institution can also as such leave you, neither you can leave the institution as such. So it is a mutual benefits between the professors and the institution. So it is the bounded duty of the higher authorities to provide you the IP policy.
Yeah, you have the right to basically, get what is the benefit sharing, or I mean, to what extent your invention or your work has been commercialized. So the institution is bound to give you that particular data.
Okay. It means that we should have to just come in front and to have to ask to them.
Yes, ma'am. Yes, ma'am. Ma'am, without you telling us what research paper you have or what research content you have, how come your principal or higher authorities or research director know that you have that ma'am, caliber, ma'am? So if you have a project and if you are going to apply for ICSSR, or if you are going to seek any funding agency within your district or something like that, it is you who has to approach the principal or the management.
Okay. Thank you, ma'am.
Yeah. Any other doubts?
One more thing, ma'am.
In case, please go ahead.
Means, ma'am, maybe now this is the awareness program of the IP, but before that one, many of the researchers, they do not know their rights. To whom should have to have which type of the question we should have to ask to the institute before joining any of the project, or many of the times they discover many of the good things and application of that molecules, but they do not know how to approach to the patent, how to
get it patented.
Exactly. All these small things they do not know, and many of the inventions, they just lie on the bench. They are not coming in front of the market.
All right.
So I think this type of the awareness we should have to spread within the 10+2 itself in the graduation level.
Yes, very true, very true. I think government is doing all possible things, to make the people and students aware of what is IP. And IP has gained popularity only in the past few years, I guess. So the government is also coming up with lot of changes. I'm sure, as you said, it has to reach to the right from the school kids, so that they can actually identify and come up with lot of creativities. But Miss Geeta, right? Dr. Geeta, right?
Yeah, Dr. Geetali Pachori.
Geetali, Dr. Geetali, if you think you have any kind of research work which can be patented, please do. You can contact me also. I will help you in harvesting your invention, or I can guide you, in helping you to further working
Yes,
on
ma'am.
it.
Actually, ma'am, I did my PhD in medicinal chemistry, and I have the 20 years experience in drug
Excellent,
discovery.
excellent.
And but
So
now I am
proud of you,
now,
ma'am.
yeah, but
Mhm.
now I am just getting aware that so much potential in the IP, because I
Exactly,
was
exactly. Yes, by having your rights protected, you can commercialize it and use the benefits you get out of it for doing further research. That is the important aspect of getting your IP protected. So it's high time that you have to start identifying the patentability aspect of your work and just go ahead and keep filing patents.
exactly, ma'am. Actually, I want to know one
Mm.
more thing. Means,
Okay.
suppose I want to
Mm.
work as a
Mm.
freelancer chemist.
Okay.
And
Mm.
for that one, because I have
Mm.
the lot of the
Mm.
experience, I have
Mm.
the small amount of the money, not the big
Mm.
amount. So
Okay.
I can
Oh.
just put one fuming hood and
Mm.
can make the few potential molecules, or you can
Mm.
say the
Mm.
some
Mm.
separation of the chiral
Mm.
molecules.
Mm.
Those are very
Mm.
beneficial in the drug
Okay.
discovery, and can go
Mm.
for the patent in a very small investment also. But many
Definitely,
of
definitely.
the
You can do
doubt
that.
is this, doubt
Mm.
is this, that whether I can put my one fuming hood in residential area or not. This is the just I want to clarify if any of the
Fuming, fuming wood.
exactly, ma'am,
What is that?
small lab in
Okay.
residential area.
As long as you abide by the environmental safety aspects, I think you can have it.
Uh, that because
Yeah.
I do not know to whom I should have to approach to just saying
Ma'am,
clarify
All
all the
right.
norms.
again, if you are in a metropolitan city, you have to approach this corporation office. If not, you have to approach the panchayat office, presenting that you are doing a eco-sensitive, fuming wood, which is good for the society, ma'am. Anything which benefits the society, the government is, they can try to take it up as a project and do it.
Okay, so
Mm.
to whom should I have to approach?
Ma'am, metropolitan city, you have to go for corporation office or any panchayat office, Tahsildar office. There you can go and meet the higher authority, ma'am. You can get the prior permission from them and get the appointment.
Okay, okay, ma'am.
Okay.
One
Okay.
more thing. I am very
Mm.
means I uh, I got the one sanctioned project, and I was the principal investigator in that project, and
Okay.
it was funded by the Department of Science and Technology,
Okay.
and in the scheme of WOS Kiran scheme. And
Okay.
it is very
Mm.
surprising that because the working place was the Banaras Hindu University, and
Okay.
see the things are here.
Mm.
My supervisor, means to whom I was just sharing my lab.
Okay.
She was asking the money. She was asking the money that you
For
have to
what?
give me the 40% of your fellowship to me, just
Oh.
giving the signing authority.
That is not right, actually.
Exactly, that is not the
Uh,
right.
uh,
This is the
uh,
only the
uh,
thing that I was thinking that I should have to put my own lab as a freelancer.
Yes, yes. If you think you have all the capacity and knowledge to back that, please go ahead and you can file for patents.
Ma'am,
Definitely.
again, if you are, if you are looking out for this GST funded and all, you have to be affiliated to the institutions, ma'am. So that is one of the limitations of the funding agencies. So for freelancers, not all the government funding agency will be providing funds. Probably, if you want to be a freelancer, you have to try with some NGOs who can fund you. But if you are a freelancer, government funding, I am not sure whether you will get it or not.
You
But if
can also, okay, as a freelancer, you can also try approaching government. There are a lot of institutions like TIFAC, NRDC and all, which can help you get funding for your invention, Dr. Geetali. So I would, if you want, I would give you the details of this NRDC. NRDC is in Bangalore as well as in Delhi. So I can give you the contact details. If you send a mail to them, they will also help you with assessing the potential of your work as well as giving you funding.
So kind of you, ma'am. So kind of you. Whether I have to share my email ID to you, or
yes,
how I can approach you.
Put it in the chat box. I will take a note of it. You can also, I will write my email ID here.
Yes, ma'am.
You can contact me. You can send me a mail.
Okay, ma'am.
I'm also sharing my mobile number here.
Okay, ma'am.
All right.
So kind of you, ma'am.
Thank you. Thank you so much.
Sai Priya ma'am, there is another question posted by Ms. Abhi regarding the patents.
Regarding?
Patent. If I am an inventor and have a patent in India, I just want to know whether patent is internationally connected.
No, what is applied in India is valid only in India. It's a good question, actually. Yeah, so I have to explain you in detail. So if you have a patent in India, I mean, if you apply for a patent in India and you would wish to enter US as well as EP as your jurisdiction, there is this provision called PCT. PCT provision through which you can file an international application, and you will have 30 to 31 months time to enter into the jurisdiction you would want to. And there are 156 countries which are members to PCT. So through PCT, you can enter generally it is a preferred mode of entering different jurisdiction. But there is generally no such concept called a global patent. What is applied in India is valid only in India. But you can use that as a priority application, which means, for example, if you're filing the invention on January 1st, 2022, so you will have the priority rights for the invention which you have disclosed right from the day you have filed the application. Any further doubts?
Or by this one, ma'am, we can just secure the prior art also.
I mean, what is that? Can you come again?
By the just if suppose if there is not such potentials of the patent, but we can secure the prior art by filing the patent.
No, prior art means which is already there in the public domain is called prior art. So if it is not patentable, then you can go in for defensive publication in order to stop others from getting a patent using your research work. So you can go in for defensive publication, but it generally it doesn't give you any monetary rights. You can just stop others from using research on which you have already worked.
Exactly, ma'am. Here in R&D centers, many of the scientists, they know that their research is not such potential, but they just file the patent, just securing the prior art. and getting the patent number and getting the promotion.
Okay, I mean, I don't understand getting prior art. Prior art means,
prior art means, suppose if I invented 4 or 5 or 10 novel compounds and I file for the patent, and I know these compounds are anti-cancer active, but it is not as such that it has not as a potential that can be commercialized. But because I have secured one patent, so that patent I will get the benefit in my promotion.
All right, you're talking that if I file patent application, I'm applicable for promotion, right?
Exactly.
Ma'am, there is
So
a process, no, ma'am. First they will file, then they will get it published. There are certain people or academicians who stop with the publication. They will not go and defend the queries or defend the any thing that comes to from the patent
examination
office.
report.
Yeah,
Okay.
they don't go for the next step of first examination report or defending anything. So there is
in
a
that
mark
case,
which is given for the patent publication. So that is what ma'am was talking about.
All right. So in that case, I mean, your application gets abandoned, right? It is just published. It comes to the, public. But you cannot gain anything monetarily out of it, right?
Exactly, but
Since
they know this is not the potential patent, but just getting the patent number and surviving of that patent 3 or 4 years, they do not want to renew the patent. But this patent number will secure the prior art of 10 molecules.
Okay, you're talking about invention coming to the public domain.
Exactly.
Right. Similarly, I mean, what I have talked about defensive publication is what you're mentioning, right?
Exactly.
But I would suggest that, I mean, if you are a researcher and you are really working on breakthrough invention, put your heart and soul to it by not thinking about promotions and by only think that you're finding solution to an existing problem in the world. So that way, you can really come up with solution for several problems the world is facing.
Exactly, ma'am. But this is for the good researcher. But some of the just name of the promotion and getting the projects, many of the researcher and academicians, they do this type of the activities.
So yeah, I'm sure they do it, but it won't help in the long run. In the long run, they won't survive, right?
But they just, because they are getting the salary, handsome salary, they just want the how many patents in your name, 10 of patents or 20 patents like this one, just they want to just put into their CVs.
Okay. Okay. Okay, something new which I'm hearing.
Ma'am, here I am just observing in Banaras Hindu University, many of the academicians, professors, they do this type of activities.
All right. Okay. That is not a good practice.
Yeah, but see, there is no vigilance here. So the people are just doing this type of wrong activities, and they are surviving, and that is now inculcating in their habit.
Okay. Well, let's hope, university also have certain policies, which takes care of all these things.
Exactly.
Maybe
But many of the universities, they do not have this type of policies, and the mature professors having the 10 years and 20 years experience, and just before they are just birds of the retirement, and they are doing very wrong activities here. And because they are in the very in the many of the committees and something big policy committees.
Priya ma'am, sorry to interrupt. This program is going live, so it is better not to use the institution name, ma'am.
All right.
Maybe you may end up with problem. That no issues from our side, but you may end up with problem, ma'am. You talk generally about the issues what you are facing without specifying the institution name.
You're talking to Dr. Geeta?
Sorry, yes, ma'am, Dr. Geeta.
I was just wondering, you mentioned my name and I was like, I did not specify. All right, all right. All right, thanks. Any further questions which I can help? All right, if you come up with any questions in future, do not hesitate to contact me. I can help you in identifying the, patentability aspects of your work. Yes, hope the session was informative.
Yes, ma'am, it was very informative. Thank you so much, ma'am.
Welcome, Dr. Geetali. Thank you so much. And thanks for patient listening.
It was very informative.
Deepika ma'am, are you there? If you're there, kindly propose the vote of thanks.
Yes, ma'am, I'm there, ma'am. Good evening, everyone. It is an honor to propose a vote of thanks for today's session. I would like to thank the Almighty for making today's session a success. I extend my gratitude to our speaker, Ms. Ipr Balasubramanian, for taking the time to be part of the FDP on research and IPR and for sharing her knowledge and insights. I thank all the participants who have taken the time out to attend today's session. A big thank you to our secretary and our associate secretary for their constant guidance and support. My special thanks to our principal, Dr. S. Padmavati, and Vice Principal, Dr. S. Rukmani, for giving us the encouragement we always need. Last but not the least, I would like to thank Dr. S.T. Deepa, our technical team, and our internal training team for all their support and coordination. Once again, I thank you all.
Thank you so much.
Thank you so much, Priya ma'am. And the feedback form is posted in the chat box. You can just fill in the feedback form.
Okay.
The participants who have filled the feedback form will receive the e-certificate for the participation.